I, Dr. Amit Joshi, welcomes you all in the National MOOT jointly by Sri Vaishnav Institute of Law and Sri Vaishnav Institute of Forensic Science at Sri Vaishnav Vidyapit Vishwavidyalaya, Indore. Before we commence, technical team to help us in this pious ritual. Now, I request Dr. Upinder Dhar, Honorable Vice Chancellor, Sri Vaishnav Vidyapit Vishwavidyalaya, to extend virtual welcome to the Chief Guest, Sri Shailendra Shukla. I request Tushar Kumar Mandal, Coordinator, Sri Vaishnav School of Law and Sri Vaishnav Institute of Law, to brief us about the National MOOT Court Competition 2022. Over to you, sir.
Thank you, Dr. Joshi. I am Tushar Kamti Mandal, not Tushar Kumar. Honorable Justice Shailendra Shukla, former Justice of Madhya Pradesh High Court, our Honorable Vice Chancellor, Dr. Upinder Dhar, my senior colleagues, and other friends, students, participants. I once again welcome all of you on this MOOT Court competition of 2022, which is being organized by Sri Vaishnav Institute of Law and Sri Vaishnav Institute of Forensic Sciences. The MOOT Court competition, as most of you would know, is held in 2 rounds. The first round has already happened, which is offline round on the basis of memorials that have been submitted by the participants all across the country. So I am happy to announce that we had about 22 teams who have enrolled for the MOOT Court, and on the basis of memorials that they have submitted, a panel of judges selected 14 best teams for the second round, which we are calling as preliminary round, incidentally, because we have just another round after that. So the students would therefore be participating in the preliminary round immediately after the inaugural session. The preliminary round would, as again most of you would know, have the format of each team playing the role of respondent as well as petitioner alternately. And the draw has made it sure that no team faces the other team in the opposite argument. So a lot of research work has gone inside, as we understood from the memorials that have been submitted in analyzing the moot problem or moot proposition, which were sent to the students or the participants some time back. And the quality of the research work that has been done so far has been exceedingly good. So I must compliment all the participants, participating students. Essentially, they are all undergraduate law students for doing a good work and being sincere. This serves our purpose of the university at large and Sri Vaishnav Institute of Law, as well as Sri Vaishnav Institute of Forensic Sciences in particular, of providing practical exposure and inculcating a lawyering skills among undergraduate students of law who are aspiring to be famous lawyers, advocates, advocate generals, maybe judges, and some of them would definitely go to Supreme Court level with this foundation that we are trying to build up. The moot court competition also gave rise to an enhancement in their or a platform or a practical exposure to enhancing their communication skills, drafting skills is so important, presentation and research skills, apart from sharpening their legal knowledge. All these components are extremely important and in developing a lawyer through moot court. As most of you again would know, Sri Vaishnav Vidyapith Vishwavidyalaya has established the School of Law in 2018 with a one-year program in LLM, and subsequently has expanded into another institute called Sri Vaishnav Institute of Law, and presently we are offering 4 undergraduate programs in law, 3 integrated with BA, BCom and BBA, and 1 LLB standalone honors program, 3 years program, apart from the 2-year LLM program. So we have been conducting moot court competition over the years, and this year we see a much more enthused level of participation from across the country. Although this is on a virtual platform, the physical mode would definitely be much better, but then I'm sure with the effort and the hard work that the team has put in, led by Ms. Amrita Singh, would make this particular competition, 2 days competition, also be very interesting and fruitful for all of us. With this, I thank all the guests and colleagues to join us, and all the best for the participating teams. Thank you so much.
Thank you, sir, for making it explicit to all of us. Now I request Honorable Vice Chancellor, sir, for the welcome address. Over to you, sir.
Morning to all of you. Respected Justice Shailendra Shukla ji, Dr. T.K. Mandal, Dr. Ken Guruprasad, all directors of our constituent institutes, faculty members, guests, and my dear students. At the outset, I would like to thank Justice Shukla ji for accepting our invitation and join us on this important occasion. As we know that mooting is an important component of legal education. In fact, even in allied disciplines, now mooting is done. When we established Institute of Forensic Science a few years back, coordinator Dr. Kavita Sharma took the initiative of organizing moot court competition every year. And every year we have been doing it. And Institute of Forensic Science has very successfully handled this important activity. This time it is for the first time that this is being jointly handled by our Institute of Law, Sri Vaishnav Institute of Law and Sri Vaishnav Institute of Forensic Science. So compliments to Dr. Mandal for keeping the tradition on. And I would also like to compliment the faculty members who have made all possible efforts to make it a very successful event. A moot court, as we know, it simulates, it's a kind of simulation. It simulates a court hearing, usually as an appeal against a final decision, in which participants analyze a problem. So in this case, students analyze a problem, research the relevant law, prepare written submissions, and present oral arguments. Moot problems are typically set in the areas of law that are unsettled or that have been subject to recent developments. They usually involve two grounds of appeal argued by each side. The procedure imitates that followed in real courts. Since it imitates what happens in real court or what had happened in a real court in a particular case, that's why it is considered a simulation. The judge enters, the mooters and the judge bow to each other. The clerk announces the matter. The mooters give their appearances and are then called on in turn to present their submissions. The judge asks questions of the mooters, the court adjourns, and the judge then returns to deliver a brief judgment and some feedback. In other words, like in management, I belong to management discipline. In management, many times we use role play. So it is more like a role play. In other words, replicating what happens in reality. In the process, students pick up the important points, important tips, and in the process learn. Mooting is not the same as public speaking or debating, although it shares some common elements with these activities. It is a specialized application of the art of persuasive advocacy. It has been part of the process of training lawyers for centuries. See, mooting, we are talking about mooting today, but it is not something in a new concept. It has been happening for years for training the lawyers and plays an important role in legal education. See, so far as our country is concerned, it was not done in traditional programs, say 3-year LLB earlier. Earlier we had only 3-year LLB. That time it was not very common. But in India, it has picked up the popularity after integrated programs were started, after national schools of law were established in the country. But the question is for the students that why mooting? Why should we have it? Maybe right now we are doing once in a year, maybe frequency may be increased in the future, but why? There are many reasons to moot. Mooting enables students, one, to engage with and think deeply about interesting and topical legal issues. Two, to enhance their advocacy, legal research, and writing skills. Three, to work closely with and learn from their peers. And fourth, to demonstrate their interest in advocacy and competence as an advocate to prospective employers. Most students find mooting to be intellectually rewarding and highly enjoyable. It can be nerve-wracking and frustrating, but it is a lot of fun at the same time. So we have seen while moot courts are happening in the educational institutions, it is learning with fun. At the same time, I would like to share some tips, the techniques which need to be taken into consideration. It is critical to engage with the bench. This requires you to bring many skills together, including maintaining eye contact with the judge, speaking at an appropriate volume and pace. See, how to speak in the court. This gives the training to the students. So, an appropriate volume and pitch, the pace, responding directly and accurately to questions is holding the judge's interest. See, a student needs to learn, a prospective advocate needs to learn that how to retain or hold the attention of the honorable judge. It also, incorporates a cardinal role of mooting. That is, cardinal rule of mooting. That is, never ever talk while the judge is talking. Never ever talk while the judge is talking. This one has to learn. This one has to remember. Further, remember that it is accepted to ask a judge to repeat a question if you do not understand it. And that it is always best to say, I regret, I am unable to assist your lordship, ladyship on that point, when you really do not know the answer. So you may not be able to, so one has to be honest in responding that way. Mooting is not just about presenting propositions of law. An important aspect is applying those propositions to the facts in order to argue for the result you want. You may be a defense lawyer, you may be on the other side. So how to present your arguments so that you can achieve your goal? You should be very familiar with the moot problem and be able to take the judge to relevant paragraphs in it. So one has to be thorough. So one cannot simply go to the courtroom without preparation. So one has to be very well prepared. The students will often make extensive use of authority in delivering your submissions. So whatever you say with confidence. You need to know what principle a given case stands for. And if a case is binding on the court before which the moot is being argued. A critical aspect of mooting is time management, because in reality, in a court of law, there are so many cases lined up. There cannot be one case one day. So many cases are lined up. Therefore, one has to learn to manage the time so that time is fully utilized. You need to be able to expand or contract your submissions depending on how interventionist the honorable judge is. Therefore, these are some of the tips. Why mooting? So it's a kind of practical exposure to the court, bringing courtroom to the educational institution so that students learn the skills which are necessary for arguing a case in the courtroom tomorrow. So it also, I would say, it helps the students to learn about the etiquettes which are very much essential in the court. So I welcome our chief guest on this special occasion and all the participants, all the contestants who are in this moot court. And I wish everybody, every student, happy learning. Thank you very much.
Sir, A vision is not just a picture of what could be. It is an appeal to our better selves, a call to become something more. Sir, we are thankful for making the cardinal and the central role of mooting. The university is always indebted to you for your visionary thoughts. Now, the inauguration ceremony of National Moot Court Competition 2022 is at a crucial juncture. It's time for me to introduce about the Chief Guest, Justice Shailendra Shukla, the former Justice of High Court Indore Bench. I must start with a saying. The future is explicit in the cradle itself. His Highness was born on 17th of November 1959 in a family of lawyers and judges. His grandfather was the president of Balaghat Bar Association. Father was judicial officer who went on to become High Court judge. Justice Shailendra Shukla acquitted his law degree from Delhi University in 1985 and joined State Judicial Services in 1987 as Civil Judge Class 2. He went on gaining promotions and worked directly with High Court on deputation for more than 9 years. He worked as Registrar Vigilance, as Director Madhya Pradesh State Judicial Academy, and Principal District and Session Judge Bhopal. He was elevated as High Court Judge on 19th November 2018 and was assigned Indore Bench of High Court of Madhya Pradesh. He demitted office on 16th of November 2021. Sir, it is very obvious that the legacy and DNA is full of law and law. Today, we are highly obliged to have you among us and eager to hear from you to shape the future of our law students. Over to you, sir.
Thank you, Amit Jod. Respected Upinder Dhar Sahab, who is Honorable Vice Chancellor of Shri Vaishnav Vidyapeeth Vishwavidyalaya Indore, Dr. T.K. Mandal, Coordinator, Dr. Guru Prasad, Ms. Amrita Singh, other dignitaries who are involved in organizing this National Moot Court Competition 2022, all the participants. I am extremely happy and very honored to be invited for this prestigious moot court competition. I have come to realize that Shri Vaishnav Vidyapeeth Vishwavidyalaya Indore, established just a few years ago, has progressed leaps and bounds in terms of its reputation, churning out quality curriculum and very brilliant alumni, especially in the field of law. I compliment the authorities for painstaking efforts in organizing this program. In our times, that I did, just as Vice Chancellor Sahab has stated, that there was a 3-year course. There was no sign of any moot court in those times. We did used to have debate. I still remember having participated in a debate that was called, the topic of it was how law can be used to control population, something like that. And we used to have debates, but this thing was missing. The students did not have a simulated court atmosphere as what Mr. Vice Chancellor just stated, which was lacking in those times. And we were very greenhorns when we used to visit courts ultimately after having passed out. So this gap has been narrowed by this very thoughtful curriculum of moot court, now in the incorporated in 5-year courses. The moot courts, they encourage, I suppose, very healthy competition amongst colleges of various universities, and benefits students ultimately in honing their skills, in acquiring traits necessary for becoming a seasoned lawyer or a judge. The rule of law has emerged as eternal unebbing flame that has helped in sustaining and strengthening a throbbing democracy of our country, and it has helped in wiping out societal inequities and ultimately paving way for all-round development. Just as Mr. Vice Chancellor stated, the simulation of a courtroom atmosphere helps students in many ways. And first of all, which when I passed out and I joined the bar, was the stage fear of real courtroom atmosphere. So many advocates, litigants standing, and we have to put our points in the limited time. So the time management has came to be understood as a very important thing, and stage fear was there. If a student constantly participates in these moot courts, then the stage fear goes away to some extent. Then how the line of thinking, a chain of thoughts should come about while arguing a case is also very important. And the importance of drafting. And because when we became judges, and moreover in High Court especially, we can't just take things lying down. We have to come prepared. And the drafting which has been in the drafts help us a great deal. Without a proper draft, questions remain in our mind, and that complicates the issues. So drafting of the becomes clearer, and then understanding of the law and incorporating the concerned law into the facts given in a case, that also becomes achieves importance. And the vagaries of a charged courtroom atmosphere also are taken care of to some extent when we adopt this practice of mooting. So to all these students who are now enthusiastically have joined the law course and now participating in the moot court competition, shall have their way much at ease when they actually enter the law court, the courts at large. First of all, with one of the biggest traits an advocate must have, I must say, is that the facts of the case must be imbibed in your mind like the back of your hand. Recently, Supreme Court actually advised, or I may say chided, a young lawyer who was not conversant with the facts of the case and was reading the facts from the High Court judgment. So the Honorable Apex Court observed that you are reading the facts as written by the High Court, which may involve a sense of prejudice as to what the court was thinking the facts to be. Good knowledge of the memory and the chain of facts in your mind so that it becomes storytelling. I must say that the more evolved an advocate is, the easier his chain of thoughts, and he is more likable to be heard. We were in a division bench. Kapil Sibbalji was arguing a very, very complicated case, but the manner in which he went about, as if it was a storytelling. So it is our request, it would always be proper that you should know your facts very properly. So these, once the facts are clear, then the focus has to be on the moot question which is involved and we should observe as to what are the strengths and weaknesses of your case and how to best project the strengths of the case. And how would you rationalize the weaknesses, if any? And the weaknesses of the other party should also be taken advantage of. That means you should have knowledge not only of your case, but of the opposite party as well. And a complete picture of the whole case along with the law involved should be there with, should be there in your mind. So proper compilation of cases, of the facts and the law involved with the latest citations. And I must say that honesty should be the uppermost in your mind. You should be careful that whatever citations have been cited are not overruled citations. Sometimes it, by way of inadvertence, it happens that you knowing that, or you that you cite a case which has been overruled, or you cite a judgment of Madras High Court, Kerala High Court, etc., or even MP High Court, when there is a specific law laid down by the apex court in that particular area. So you should be careful to see as to what the apex court has said, has stated on that particular subject. If the apex court is has not made any, laid down any such law, only then the citations of courts, high courts, assume importance. Now, this I have seen that the moot courts, I have attended a few moot courts. There is the students are very, very eager and they display their skills. But I must say that the scope of courtroom theatrics and prolix arguments have of late given way to more precise, laser-like focused approach. This has happened because there is huge pendency in courts, and the courts are generally in a state of hurry. The central point involved is that how best to render justice in more and more cases, and it is to be seen that most of the list gets exhausted, list of cases gets exhausted. So judges' mind is focused on that aspect as well. So what happens that only argued should be taken up. It is in the olden times, we see that even when I joined the bar, I could see that arguments used to go on in one particular case for hours together. Now the picture has completely changed. Few minutes in a case and that's over. And that is why we are required to study a lot before sitting on the dais. We just know in each file I used to write particular point involved and I have to ask only that question. So what you will see in real courts now is that as soon as you appear, the judge would ask you the most focal point. He knows the facts mostly. Actually, there are two types of judges. Some judges who are very experienced, they don't, they would rather come with, because there are similar facts, ultimately with years of their working as a judge, they come to know that. So what happens is that they would not be prepared. They would rather think that if they prepare the case, they would get prejudiced in one way or the other. The other set of judges would come prepared and ask the focal question. So you have to gauge as to what kind of judge you are facing. A judge who is well prepared would always be asking you the focal questions, and judge who depends upon the advocates to enlighten them would give you more longer rope to argue case for a longer while. So you have to gauge as to what kind of a judge you are facing. Constantly being involved, they excel at catching at the root of the problem. So we cannot hoodwink or try to highlight minor points, but we should always be aware that the judge is ultimately going to ask you that focal point which would either win the case in your favor or may just be lost. But supposing if you're not able to, Mr. Vice Chancellor very aptly stated that it is not good to cross swords with the opposite party or with the judge. If you think that the judge is not convinced then with your argument, then you should never in any manner, by way of any means, try to show your exasperation or frustration, because that tells upon you only, and the judge, it does not show, your image does not go down well with the judge. A losing, even if you lose, you should be gracious and dignified enough to accept that, because every case is not fought to win only. You should know the strength of your case and you try to do it as best as possible. Ultimately, the thing is that one should be very amiable and with pleasant mannerism and very confident. You should not be inclined to interject when the judge is speaking, as Mr. Vice Chancellor has stated. That is correct. And one more thing is that you should not browbeat your opposite counsel. You should let him have his say and jot down whatever he's saying. And then when your turn comes, again, you can throw light on what he had argued. And the personal rivalry should not result in acrimony with your rival party. That is also very important, because it all tends to enhance your own image before the judge. I have seen that many senior lawyers that somehow try to raise their voice and try to be one upon the judge. So these things are go down. These things the judge tends to accommodate them for a while, considering their seniority. But ultimately, this advantage does not reach far. The senior advocates then tend to lose their, the which have accrued to them, and because ultimately it is the pen of the judge which matters, and at the level of a high court or any other even lower court, such acrimonious and loud speaking does not work much. We have seen the best of advocates through video conferencing in last 2 years during Corona pandemic times, because that was one of gave opportunity to advocates from all across the country to argue, which was before MP High Court, which was not possible earlier. So it was great exposure to all of us to see eminent lawyers arguing their cases, and what a what an enjoyable time it was. I wondered as to where these people, how why such arguments should be heard by all the students also. There should be something, some arrangement made by the universities, law colleges, so that they can now, there is a live streaming of arguments also. So now this should also be added in the curriculum, that important arguments be live streamed so that judges, these students get more and more opportunity to see the real courtroom mannerisms. What I would say is that you should be the best, try to be the best, and always consider that with lot of work and labor, you will come out supremely. And and in the end, I would advise these students and participants that the path which they have taken is arduous, involving lot of labor. No immediate monetary gains are there, so they have to they have to be ready for a long journey ahead, which in the end would be very, very fruitful to them. Even their parents should know that after passing out, have to give ample time to their wards to imbibe the nuances of law practice and achieve success. I think I have overshot my time. I congratulate all of you in advance, and may you have great success ahead. Thank you so much.
Sir, your words of prudence and this simulation is definitely going to be the right cradle for the upcoming lawyers. Now, I request Dr. Guru Prasad sir to propose the vote of thanks. Over to you, sir.
Thank you, Dr. Amit Joshi. On behalf of Sri Vaishnav Institute of Law, Sri Vaishnav Institute of Forensic Science, and Vaishnav Vidyapit Vishwavidyalaya, I thank our Honorable Justice Shailendra Shukla for accepting our invitation and also inaugurating the MOOT court competition of 2022. He gave a very valuable tips in his address. The simulation of court will be a practical experience to all the students who will be taking up this job of participating in the court proceedings in various ways. As the chief guest has pointed out, the education has been evolving from time to time, and we are incorporating more and more practical experience in every aspect of our education, irrespective of the subject. And the education in law also has adopted this same learning methods in the form of MOOT court to give a practical experience to the students. He has also pointed out a very important aspect of maintenance of dignity and image while presenting cases in the court. And also, this is an important aspect that the students need to learn, and the MOOT course may help them to learn it. The use of technology, particularly in the COVID times, like the present meeting we are having online, virtual meeting. So the justice has pointed out an important aspect that the technology can be used to train the students also, particularly
by exposing them to the live stream of court proceedings and arguments in the court, so that they can learn from the learned people and the learned lawyers and judges about the court proceedings. So I hope these things will be incorporated in the times to come, and even in our university. I also thank the Honorable Vice Chancellor, Professor Upinder Dar, whose vision has always helped in organizing the training programs and other programs for the students, including MOOT Court. My sincere thanks to all the participants of this program, and thanks to all the colleagues who have joined in the inauguration of National MOOT Court Competition of 2022, and the good work the coordinators and the organizers have been doing in arranging this meeting. Thanks to everyone.
Before concluding the beginning, I request all of you to raise for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you very much, Justice Saab. Thank you. Thanks a lot.
Thank you, sir. Thank you.
Thank you so much, Suklaji, and we'll have your guidance again and again.
Okay. Thank you so much. Yes, of course, I will be always be there. Thank you so much.
Thank you. Good, Amrita. अब start करो. निकल गई. Start करो अभी. Next round.
Yes, sir. Thank you, sir.
Okay. चलो. All the best.
Thank you, sir.
मनसी लग रहा. Thank you, Dr. Amrita.
So not a doctor yet. Thank you, sir.
So you will be continuing with the program?
Yes, sir.
Okay.
So we are living here, but right now we are going to start the